nearly all clients contemplating separation need to think about a will, don't they?
So each financial arrangement is very different because every family is so different.
A divorce requires the change of a will, but so does a remarriage.
Unfortunately, with children with additional needs, we don't always know that's going to be the case, and actually they may be dependent for life.
And can the litigation friend be anybody?
We must always know our clients, any client, know your client, know them inside out to be able to represent them the best we can.
Hello and welcome to this edition of my podcast. I'm really excited today because I'm going to be speaking to Leah Ellis, who is an associate solicitor in our family department. Leah specialises in separation and divorce within families and with a particular knowledge and experience of dealing with children with additional needs, maybe neurodiversity, and also when perhaps one partner to the relationship also has such additional needs. So we will be dealing with those specific issues as well as what you need to be aware of when you are going through a separation in terms of the work that I generally do, such as making a will and if the unexpected happened. So, hello Leah, thanks for being here.
Thank you for having me, Melinda.
So we often find ourselves speaking about a client that's come to see you. We talk about their particular circumstances, but nearly all clients contemplating separation need to think about a will, don't they? So can you explain to our listeners why they need to do that?
Absolutely. You often find that when parties have been married for a long time, they've made a mirror will. So they've essentially left everything to each other. But of course, when they divorce, they won't want that to be the situation anymore.
Yes.
So at the very beginning of the matter, we can discuss that and they can come to you where you can make wills in contemplation of the divorce to reflect their new wishes.
Yes, that's right. And they often need to make the will again, don't they? Because of they don't really know which financial position they're going to be in when they come to seek advice regarding a divorce, but it progresses that they then find themselves in that different financial position.
Yes, absolutely. So I would always refer them over to your team where they can have that conversation.
Yeah. And can you explain about the specific thing about a jointly owned property?
Yeah, so with a property, there's two ways that the clients will hold the property. They can either hold it as joint tenants or as tenants in common. We tend to find that most married couples do hold it as joint tenants. So essentially, if one of them were to die, then their legal interest will automatically go to the other party. But at the start of the divorce, it's a consideration to have of whether actually they do want to sever that tenancy. So as if the worst were to happen, then their interest in that property is protected.
Yes, I suppose it's a bit of a gamble in a way. If you think they're going to die during the divorce, you might leave it as it is.
Absolutely. And there are situations where actually the tenancy isn't severed and the worst does happen.
But the alternative is to at least protect 1/2 share of the property by severing the joint ownership at the land registry and making a will leaving your half to whoever you want it to be.
Yeah, absolutely. And that's a conversation they can always have with the private client team.
And is that wise even if they don't know whether they're going to end up with a share of the property or how much of the property following the divorce?
So the benefit of severing the tenancy is that it then protects their interest.
Yes.
And then if they were to pass away, then it will go in accordance with their will. So then it's going to whoever they want it to go to rather than automatically going to their spouse, who is soon to be an ex-spouse.
Fine. And then, of course, if that property is sold and they move on in their own life and buy a property or through the divorce proceeds, they will probably need to look to make a new will and seek further advice.
Yes, absolutely. And we've always got the private client team on hand to speak to them at every stage of the divorce process.
So just to be clear to our audience that a divorce requires the change of a will, but so does a remarriage.
Yes, absolutely.
Any marriage invalidates the existing will that you've got, and you refer to the intestacy provisions, so you should make a new will in contemplation of marriage if you want again.
Yes.
So then moving on to provision for the children in the will. So if you've got a couple that are separating, divorcing, and they've got children, then they will want to make provision for their children, one would think, in their will. And we in the private client team work very hard on advising clients with children who have additional needs, may never be able to manage an inheritance themselves. But I know that in separation there is also specific consideration to be given for children with specific needs.
Yes, absolutely. So generally the law's view is that children at the age of 18 are dependent, although we know that really they're dependent a lot longer. Legally at 18 they're considered independent. Unfortunately, with children with additional needs, we don't always know that's going to be the case. And actually, they may be dependent for life. And that's something that we have to consider.
So what are the additional... My understanding of the divorce process, I leave very much to you, but I know that you have the financial aspect and then you also have arrangements for the children. So how are they connected in most cases, and how would they be specifically different if a child of, let's say, 15 isn't anticipated to go on to be as independent?
So we do have 3 different processes that, although they're different, they all interlink. The divorce is very much different to the financial remedy,
right.
And the financial remedy separate to the children arrangements. But of course, as you've said, they do all interlink. So with a child with additional needs, you have to consider them being dependent longer than being 18. And you may, for that reason, consider a departure from equality, because actually they're not going to be financially dependent at 18 and they might not go out to work and they may not go and live on their own. So you have to consider making provisions for them in the home with their primary carer.
And is that to... the primary carer is not expected to go to work in the same way that they would ordinarily be expected to provide for themselves?
It would be unique. Every single situation is unique in its circumstances. So you may have some where the primary carer does continue to work, or you may have some where actually the child's needs are so great that the primary carer won't go out to work. So we would have to base every single discussion on the unique circumstances.
Wow, that must be quite a lot of intense work.
It is.
And do you find that you have to get reports about the special circumstances, use experts?
Yes. So we've touched on neurodiversity, and people often talk about the spectrum, and it is so vast. So you will often have to rely on reports from specialists that detail the child's individual needs.
What would happen if a couple were separating and they had a child of 5 where it was thought that potentially that child had additional needs, particularly elements of neurodiversity that can't be particularly established at that age, and the couple want to try and finalise their financial arrangements? Can they, or is it more advisable to keep it open and return to the case?
We do have the option of reviewing matters. So we would get reports from, say, locally, the Lighthouse, that can detail the child's additional needs, and we'd look at getting a child diagnosed as well, if we can, as part of the process.
And if a child with additional needs or without is the parents had chosen for the child to go to a private school, for example, is that something that is taken into account when the financial arrangements are such?
Financial agreements as well can be very specific. And for example, we could make an agreement that the non-resident parent would pay towards a child's private education. So each financial arrangement is very different because every family is so different.
Yes. And do you find that the parents, obviously you act for one and the other parent is represented by another solicitor, do you find that there are often disagreements despite the situation with a child that has such needs?
In family law, the family solicitors, the aim is to work collaboratively because we're trying to work together towards the same goal and not bring additional tension to the situation. So we should always try and work in a way that brings the parties together amicably. As you say, of course, they're divorcing for a reason. So unfortunately, it's not always a smooth process and they can have different opinions.
And in the best interest of the child, I suppose, is
Yes.
a very important factor. What happens about residency, or I'm not sure if it's still called contact, is it?
So you have child arrangements now.
Right. And what about if the child needs are such that they need a different pattern than would be the norm to take care of them? Maybe they're not adaptable to go and stay at a parent's for the weekend and live with another person. Do you need reports to evidence that? And are the arrangements set down, or do you go to court?
So you tend to find that children with neurodiversity, such as autism, they strongly need routine and stability, and those changes to a neurodiverse child are much more difficult for them to process than what they can be a neurotypical child. So within Children Matters, you can deal with things voluntarily, and we try to get the parents to negotiate an agreement between them. Unfortunately, if the parents can't agree between them, then that's when you would perhaps be looking at a court application. So there's two ways of dealing with the matters, within court proceedings or outside of court proceedings. But as you say, if one parent is saying our child needs this stability and the other parent doesn't agree, then that's when we would have to lean on expert reports. It's also very common for one parent to perhaps not support the diagnosis.
Yes.
Or it's a difficult, I have an autistic son myself, and I know it can be quite difficult to accept that your child does have what is a disability. So we would sometimes have to rely heavily on the reports of experts, on school reports, because school will see whether a child needs routine, needs stability. So it's helpful to have reports from all angles.
Yes. And you mentioned your own son, and I think that's perhaps one reason why you're so knowledgeable and empathetic to your clients, but also it's really important, isn't it, that clients are as open as possible about the additional difficulties that they may be experiencing.
Absolutely. And I also think a lot of my clients take comfort in the fact, because I share with them with my own son, because I can relate. And silly things like taking a different route to school one day. Actually, if there's roadworks and you have to go another route, you might not think anything about that. But to a child with additional needs, that can be quite anxiety inducing. So it's nice to be able to relate to my clients, and I understand the problems they're presenting to me without them having to explain it in too much depth.
Yes. And those sort of pressures and thoughts and extra things to think about can, of course, be part of what's placed a burden on a relationship to begin with, different parenting skills. But then going forward, when you're trying to deal with somebody's future finances as well as their child arrangements, if that impacts on where the person can work or what hours they can work, they need to be saying that to you, don't they?
Yes, absolutely. And at that point, you can often request medical evidence that may report on how that affects the ability to work.
Yeah, really, you're really good at this. I mean, I know, and I can always see how much your clients rely upon you, because they trust that you will explore with them exactly what the impact is. And I know myself from dealing, as I have done with people at parents of MenCap, and we make special provisions in wills. It's so important for people to be open and honest about the needs, because otherwise we don't give them the legal protections that perhaps they could have.
Not, we must always know our clients, any client, know your client, know them inside out to be able to represent them the best we can. But also, like you say, more so with children with additional needs and even clients with additional needs.
Yes.
So it can often be helpful to say to them, how can we help you? What adaptations do you need to make sure you can access this legal provision as much so as everybody else?
We were speaking earlier today about a case where it was possible that one party was still coercively controlling another in terms of trying to get them to agree to a settlement. So a different type of need that your client, the other party, may have had. In fact, it was in this case. But if you feel you have a client come to you who is being persuaded to agree to a financial deal on a divorce that isn't fair, and doesn't appear to be in their best interest. What do you do about that?
Unfortunately, we do see a lot of coercive controlling situations, and also sometimes just the pressure can make clients just want to settle as quickly as they can. All we can do is give them the best advice that we can, and advise them that actually they probably are entitled to more, and let's explore that. I'm always conscious to say to clients that financial disclosure is advisable. Some people will want to bypass that, but we must stress the importance to explore the finances and what there is, because how can we advise anybody on a settlement before knowing what there really is? So really we just have to slow it down and take it one step at a time.
And what about if your client appears to have an inability to fully understand complex financial arrangements? In other words, their instinct is that perhaps they want to get divorced. So they've got the capacity, if you like, to understand that. But your feeling is they don't have the intellectual capacity to understand negotiating the finances.
We're very lucky at Giles Wilson in that we have lots of departments under one roof. So we also have a court of protection team. And I can often refer to the team and say, I'm concerned that I have a vulnerable client here. What do you suggest? So we can look at capacity assessments if we think that is needed. And then they do have the option of appointing a litigation friend to assist them through proceedings.
Yes. So they would have a litigation friend who the court would approve, who would do the negotiations and sign the consent order eventually, I suppose, on their behalf?
Absolutely, and who can just support them through the proceedings and make sure that it's a fair trial, because everybody has a right to a fair trial. So we must address any barriers to that and make the necessary adjustments.
And can the litigation friend be anybody?
You can get professional litigation friends and they are usually recommended.
Right, but it can be someone's brother, sister, mother, friend?
They can't be related to them.
Okay.
And you usually do get professional litigation friends.
Oh, interesting. And are they solicitors or?
You can get solicitors as a litigation friend, but it's usually not a solicitor.
Right. But the message is, if somebody you know is going through a divorce and you're concerned that they are being put pressure upon or they haven't got the understanding to deal with it themselves, to suggest to them that perhaps even you go with them to the appointment and you tell the solicitor they're not really understanding what's going on.
Yes, absolutely. And like I say, if I ever had concerns, I can always consult the court of protection team as well.
Yes, and we would eventually, of course, potentially end up with a court of protection order where somebody's appointed deputy to manage that person's affairs. So there's a difference between a power of attorney and being able to litigate on someone's behalf.
Yes.
Well, Leah, it's been fantastic speaking to you. We could speak for an awfully long time about this, but thank you for being here today, and thank you to all of you for listening.